Thank you very much. I would like to firstly make an apology on behalf of my colleague, Professor Jelena Arsić, who is supposed to be here with me, but however, she has a flight that is scheduled at 3 o'clock, so it was impossible for her to be at the same place here and to be on time on the airport. So, besides her and me, this report concerning the rights of the child in the private law in Serbia is written also by Professor Gordana Kovaček-Stanić, and I'm sure that many of you know Professor Gordana, and Professor Sanja Savčić, who is also from the Faculty of Law, University of Novi Sad in Serbia. So I would like to thank the previous speakers, especially to Professor Alexandra and Professor Anica, because they made some really important things, because it makes my job easier, because there are so much similar things with the Serbian-Croatia law, and that will make my presentation faster and the lunch closer to us. So, yeah, so I will briefly just give you some information concerning the Serbian rules concerning the position and the rights of the child. First of all, the laws and the regulations in the area of private law does not define who the child is. But that is not the same, for example, in public law, especially in criminal law, where the child is defined as a person under the age of 14. However, of course, we accept the definition given by the UN Convention on the Rights of the Child, that the child is every person under the age of 18. And the legal capacity, the full legal capacity, also is attained at the age of 18. So, there are some interesting things that I will like to mention, because I will skip those things concerning the rights of the child to enter the marriage, because the professor, please help me, the professor Tomea, yes, thank you very much. She also gave a very nice comparative picture of different countries, and mentioned that some kind of capacity is acquired at the age of 16. Actually, a child at the age of 16 can ask for the approval of the court to enter the marriage, and if that approval would be given, then the child entered the marriage and then gained the full legal capacity. However, some rights child can obtain before the age of 18, and those rights are numerous. For example, at the age of 15, the child can undertake the child actually can manage and dispose with his earnings and property acquired through his or her work. At the age of 15, also the child is free to make a will. Then he can choose, or she can choose, which secondary school he wishes to attend. The child can decide on maintaining personal relations with a parent, and as well as with a parent with whom he does not live. Interesting, at the age of 16, it is the same. The young woman can decide whether or not she wants to terminate the pregnancy, and at the age of 15, the child can give consent to a medical procedure. But there is some interesting thing in the practice that makes this right a little bit delicate, because at the age of 15, child can give some consent to medical procedure, but when the child does not give such a consent, then the consent will be asked from the parents. So the child actually is not free completely to decide on that matter. Furthermore, I will skip these things that you can read in our report, because I think they are pretty much the same concerning the status of a child in the field of inheritance law, because they are pretty much the same as in other countries. Children have different rights concerning legal and testamentary inheritance, and then there are some rules concerning forced heirship. But I would like to give you some insight concerning legal transaction capacity. Actually, legal incapacity lasts until the 14 years of age, as we already heard, but during that period, until the age of 14, child can, there are some exemptions, because there are some things that child can do, actually some contracts that child can conclude. Those contracts are the contracts of small value, the contracts that, that makes child acquire some rights, and contracts that do not acquire rights and obligations at all. So the full legal capacity is, I will repeat, is attained at the age of 18. However, between the age of 14 and 18, there are some legal transactions that child can do, but with the permission of their parents or guardians. Furthermore, just a second. Furthermore, I'm not sure how many young people want to found and register their companies. But under the Serbian law, it is forbidden. The founding of a company must be done by an adult. However, the child can be a co-founder of a company if a parent or a guardian act as a co-founder. And furthermore, minors can become members of the company, and inheritance is the most common way for minors to become members. So when we are talking about some disputes between parents, concerning the proceedings dealing with custody issues, child support, protection from violence, and etc., there are some rules that are given to the children. First of all, the child has the right to be heard at the age of 10, and then at the age of 10, a child may alone or through some other person refer to the court and ask the assistance in exercising the right to participation. Then, when we are talking about the disputes that are dealing with the parental responsibility, then the child, as I already mentioned, the child who is capable of forming his or her views has the right to freely express them in matters concerning parental responsibility, and at the age of 15, a child can decide with which parents he or she wants to live and how she will maintain the relationship with the parent with whom he or she does not live. And there are some interesting things concerning the family status of a child, actually concerning the rules who is the father and who is the mother. We accepted a long time ago, and that rules exists today as well, is that the mother of the child is the woman who gives birth to a child. In that way, we actually forbid surrogacy. Concerning the paternity, there is a legal presumption that the husband of the mother is the father of the child. And that presumption is also applicable if the marriage ended due to husband death within 300 days after the termination of marriage. And when we are talking about these issues concerning the establishing or contest the maternity or paternity, there is something that is maybe interesting to mention. First of all, there is no limit for the child to start the procedure, as for example in Croatia there is a limit 25 years old, yes. According to previous law, in our country the limit was 26 years for the child, but today for the child there is no limit to start the proceeding where he wants to contest or establish paternity or maternity. And interesting thing is that, of course, the DNA testing is something that is I think most useful things in those proceedings. However, according to our law system, our system does not impose obligation of the alleged mother or a father to undergo DNA testing. This, of course, makes making a decision for the court very hard, but during the years of such rules, there is established conduct of the judges that the refusal of the alleged father to take the DNA analysis is commonly treated in favor of establishing paternity, even though DNA testing, of course, can be done very, very easy, but however, we cannot force, yes. Well, yes, yes, of course, yeah. Of course, our system also gives the protection to children who who live without parental care. The most suitable and the most effective alternative certainly is adoption. And according to our legal system, the adopted children has the same right and the same obligation as the rights who live with their biological parents. What I wanted to also address, I think I have, there are of course a lot of things that will be missed today, but what I wanted to also mention today is the rule, because if I understood you well, if there are disputes between the parents concerning some child's rights, for example, whether the child will change his residence, then the final decision will be made by the court. Actually, the court will say who is the parent who will make decision. Yes, of course. I think that this is a pretty much good solution, because in our legal system there is a practice that when the parents cannot make an agreement, then the one parent issue a proceeding in order to other parents to be deprived of the parental rights. And I think it is very unsuitable way to solve this matter, because, you know, if I don't want my child to change his residence because I will not be able to see him regularly, then the father of the child can sue me and try to for me to be deprived of the parental rights in that area. And I think it is not a good solution. I think that there are some examples of some countries that have solutions that in those situations the court will make final decision, not the parent but the court. But I think that the deprivation of parental rights is extreme measure. And since I already have 30 seconds, I will stop here and call you to read the whole report that will published very soon, I hope. Thank you very much for the attention.